And the others can join us as we're in progress, right?
Yes. Give me just 1 second here. All right, we are good to go, Steve.
Great. Good afternoon, everyone. Welcome to the third meeting of the Subcommittee to study proposed adoption of anti-discrimination language in the North Carolina Rules of Professional Conduct. Members of the subcommittee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest or appearance of conflict. Are there any conflicts that anyone would need to bring to the attention of the subcommittee at this time? Okay, hearing none, we'll go forward. I want to welcome everybody to this meeting. We have up to this point explored the issues of the constitutionality of what is proposed, what has been proposed by the ABA. We've explored some language from other jurisdictions. We have Brian and Carmen have broken down for us I think some ways that we can look at the various aspects of what we might draft that may pass constitutional muster. And today we wanted to review, I think, some instances of those grievances or disciplinary actions in other jurisdictions, and to definitely look at some proposals. We have a draft off between Brian and Carmen that we're going to look at. So that said, I'll turn it over to Brian and Carmen, and we'll forge ahead.
All right, Steve, I think we do have just a bit of business to take care of, even though these minutes were previously approved, or at least not approved, but they were included in the Ethics Committee agenda. I think it'd be appropriate to get approval of our meeting minutes from our October 13th meeting.
All right, we need a motion to that effect, right?
So moved.
Second?
Second.
All in favor of approving the minutes from the last meeting?
Aye.
How do we do that? Do we do that by button or?
I think, yeah, well, I see the votes are coming in. Everybody's getting very familiar with our Zoom process, but I heard some ayes, so I think it's safe to say they're approved.
All right, good. Now I'll turn it over to you, Brian.
All righty, that sounds great. Good afternoon, everyone. I hope everyone is doing well. I'm going to go ahead and share my screen as we begin this particular subcommittee meeting. Carmen and I kind of put our heads together to talk about disciplinary considerations. You may recall that we started off with kind of a phased approach here, with education being the first phase. As Steve said, talking about constitutional concerns, other state variations on anti-discrimination language. Today we're going to talk about some disciplinary considerations, but we're going to approach this a little differently. But before I get to that, I just wanted to make sure that we're all up to speed on what's going on with this subcommittee and with the Ethics Committee in general. As you all likely remember from, I guess it was 2 weeks ago now, the Ethics Committee and the Executive Committees received all the different comments that were submitted on the proposed amendment to the preamble. And in light of those comments, which were both in favor of and opposed to the preamble proposal, they have sent the preamble to this subcommittee to study. We're not going to tackle that today. We wanted to continue on with our educational phase and our educational efforts. So we're going to tackle the preamble perhaps at a later point. We'll discuss that at the end of this meeting as far as what the next steps of this subcommittee should be. But just wanted to make sure that we're all on the same page, that has been sent, the preamble provision has been sent to this subcommittee for study. And just as an update, we're still in the process of scheduling the subcommittee meeting that is going to be discussing or continuing its discussion of the potential comment to Rule 1.1 on implicit bias and cultural differences being a part of lawyer competency. As far as another thing that you're going to see in your materials, and I'm not going to go into great detail here, but there has been some movement on the case out of Pennsylvania. As we talked about, I think at the very outset of this subcommittee, there are two challenges that are that seem to be some of, if not the only, real direct challenges to a state's anti-discrimination rules. The one in Pennsylvania is probably the most intriguing one. Pennsylvania adopted their version of 8.4G earlier this year, and they received, they got sued in federal court in August of this year, challenging that rule, its constitutionality, and whether or not I guess asking for the court to declare that it is unconstitutional and not allow the Pennsylvania State Bar or their court system to enforce that rule against lawyers. So what we're looking at here, like I said, the complaint was filed in August, and a motion to dismiss was recently filed, along with a motion for preliminary injunction. The State Bar filed a motion to dismiss, and then the petitioner filed a motion for a preliminary injunction. Those matters are in your materials. I included them not to, again, talk about them in depth at this meeting, but just to have them as an FYI. I think they're an interesting read, highlighting the different aspects that we're observing here. Those particular motions are scheduled for oral argument on November 13th. So we'll keep you updated as those things progress. The draft proposals, before we get into the disciplinary considerations, Carmen and I wanted to I guess just take a bit of time to talk about draft proposals, what we have there in your materials. So Carmen, do you want to kind of go through what folks will see in the agenda, and we can talk about the approaches and see if there's any discussion about those matters?
Yes, I will sum up, and we might maybe just stop screen sharing for a minute because we've got nothing interesting to show. I prefer to see people's faces. So as you saw in the materials that were circulated, Brian and I did what I believe, Mac kind of nudged us to do last time, which is give us something, give us a proposal, give us something to start with, something to work with. And I just think this is a really, really interesting experiment because we truly did not confer with each other at all in coming up with our respective proposals on what this subcommittee might put forth on this topic. And so what you see in the finished product is two really different approaches. Brian's is certainly more comprehensive than mine in the sense that he integrated language in the preamble and language in Rule 4.4 and language in Rule 8.4 that would cover different pieces of it. So just what I will start by saying, because I think this is probably one of the most important parts, is what we share in our two proposals are certain exceptions that we both believe are constitutionally necessary if we are to have this kind of regulation, namely the indication that any kind of anti-discrimination rule doesn't limit a lawyer's ability to accept, decline from, or withdraw from representation. So that principle is consistent in both of our proposals. Also, the statement that this kind of rule does not limit a lawyer's ability to advocate or advise on legal issues. So both of those are there. I'm going to start with Brian's proposal just to give the bullet points. Brian's indicates, so his preamble language indicates essentially that it is incumbent upon lawyers to avoid disrespect or discourtesy based on an individual's status in one of the protected classes, and explains that this, the need for that is because that kind of conduct undermines public confidence in the justice system. And that's, again, the very short version. We're trying to move along. Brian then went to Rule 4.4, which I think is really interesting. Rule 4.4 is actually one of my favorite rules. And I use it a lot in the particular type of disciplinary cases I specialize in, but it is the rule that says that it is misconduct for a lawyer to engage in behavior while representing a client that has no substantial purpose other than to burden, embarrass, or harass, I believe. I might not have those words exactly right, but essentially useless behavior that is designed merely to target and negatively affect another person. And so Brian went to that rule, which seems like a good place to think about the positioning of anti-discrimination prohibitions within the rules of professional conduct. And he kind of expanded the notion of what constitutes prohibited conduct that has no legitimate or substantial purpose in advocacy to explicitly include, and the words he used were conduct manifesting, engendering, or tending to appeal to bias against a person based on that person's status. So he just expanded it from a general prohibition on not engaging in useless oppressive behavior to specifically state that discriminatory behavior of this kind would fall under the prohibition of that rule. In Brian's version of Rule 8.4, proposed amendment to Rule 8.4, he adds an additional section, and the additional section prohibits sexual harassment or discrimination that is unlawful. So that section is tied to whatever the substantive law is on sexual harassment and discrimination. It does not, however, indicate that the unlawfulness has to be determined by an outside tribunal or agency. So it would be something that had to be determined in part of the state bar's analysis of the conduct did the conduct rise to the level of violating substantive law? So that's my sort of short take on Brian's proposal. I was much more simplistic in my approach to this. I started directly with Rule 8.4G that was proposed by the ABA and cut out all the parts that I thought were superfluous or potentially constitutionally problematic. Then I started moving parts around. The ABA rule had what I considered to be a lot of very important either definitions or exceptions in its commentary. I moved those up into the proposed rule itself. So the proposed rule would have a definition section, would have an applicability section. I retained the state of mind requirement in the ABA rule because I think knows or reasonably should know is a fair standard under these circumstances. I, made a few adjustments to the language on, what kind of capacity are we talking about here? It's obviously not a lawyer in any circumstance. I selected in a professional capacity, and I did that specifically because I have some concerns about making sure that such a rule would be applicable to professors, to law professors or lawyers in academic settings. So I didn't want to limit it to courthouse work or client representation. And along those lines, I also took to heart the ABA's pretty extensive discussion of concerns about sexual harassment within the legal profession. And that seemed to be something that the ABA believed was worth addressing and targeting with this kind of rule. So I crafted my rule to include that. I recognize that there are certainly some significant disciplinary considerations in having a rule that includes sexual harassment, that there are some proof problems, there are some scope problems, and hopefully we're going to address some of those through the hypotheticals today. Included in your materials is the whole list of all of the modifications and decisions that I made, and along with the draft rule, but those are the two proposals. They are very different, I think, in what they would cover. And so perhaps one of the things we can do as we go through some of these hypothetical fact patterns today is talk about whether one or the other or both would cover the facts that we're presenting to you. Brian, did I omit anything of significance about your proposal?
No, I think there's there's all these little nuances that we talked about at the beginning of this whole process that my mind is going, oh, but let's talk about this aspect. I put this in here to avoid any vagueness issues. But that's something that I think is, like you said, that's not the purpose today, unless the subcommittee wants to really get into that. But I think we really want to talk about these hypotheticals today.
I think the subcommittee wants us to stop talking. That's what I think.
Yeah. Dorothy, I see you have your hand up.
Yes, I just want to comment, if I could. First, I want to say that I think that you both did a phenomenal job in this drafting, and I appreciated the different perspectives that you came from. And I would love to see a way to merge them, pieces of them together. Carmen, you pointed out the very pieces that I really like from both. Especially I like the how much more detail Brian's is, but I like some of your language. I would love to figure out a way to have the detail of Brian's, but then know or reasonably should know constitutes language of yours to incorporate it over here with Brian. You know what I mean? And I like the whole 4.4 references in Brian's, because I think that's all necessary. But of course, to weave in that standard there. I also like, and I think it's in yours, Carmen, about the employment discrimination and how that would only be addressed if it has gone through one of, the proper tribunal on the outside, the EEOC and all of that good stuff. And I think you're shaking your head, so I must be right that it's in yours. So I just wanted to point that out. I'm really excited about kind of where we're going with this. And yeah, so I just wanted to just share that.
Thank you, Dorothy. I really appreciate it. And yes, I'm glad you mentioned that. That was the piece about the employment discrimination was definitely crafted with my deputy counsel hat on, because I personally don't want to get into the business of trying to litigate federal employment discrimination cases within the Office of Counsel. So that seemed like a good carve out to me, that's something we're going to have to let somebody else decide before we get involved. Any other questions, comments on the proposals?
All
right, well, we're going to, especially at the insistence of Gray Wilson, who isn't, I don't think, with us yet, but he's definitely tired of hearing us talk. So he proposed last time that we give you all some actual facts, some stop operating in this purely cerebral realm and try to tie this to some facts. And so that's our plan for today. So Brian, you want to go back to the screen share and I'll tell them a little bit about our game plan?
Yep. Good to go.
So what we have done is we have put together hypotheticals, some of which are derived from the cases that were in your materials, others of which we got from law review articles, we've gotten from various materials out there in the world that are criticizing or have concerns about these kinds of rules. Probably a couple of them were a matter of creative writing, but our plan is to go through a series of hypotheticals. We will put the very, very short fact pattern up on the slide, and we're actually going to ask the subcommittee to respond by poll as to whether they believe the conduct that is described warrants professional discipline. Now, this is not a binding thing, it's an anonymous poll. We're just kind of trying to get a straw poll, get some sense of what the subcommittee's preferences or thoughts are on some of these types of potential misconduct. So the first question we'll be asking you is, does this warrant professional misconduct? We'll launch the poll, we'll share the results of the poll, we'll ask you all to comment or discuss the fact pattern to the extent you want to. We will be happy to weigh in on whether there are existing rules of professional conduct that would or could potentially be used to address whatever fact pattern we have provided to you. And then for some of them, we do want to talk about whether there are concerns from a disciplinary perspective about either proving or investigating or prosecuting these kinds of claims. So that is the plan. I will say at this point, particularly because we probably have a wider audience than just those who are on the Zoom, that because we are pulling a lot of these hypotheticals from real fact patterns, there is language in the following slides in the hypotheticals that is deeply offensive. There may be some descriptions of conduct that are troubling or upsetting to people, but this is not a conversation that can be had in a meaningful way without being uncomfortable. And we made the determination that it's important for us not to sort of soft focus what it is we're talking about here, what kind of conduct actually occurs. And I think that will better allow you to assess how you feel about how we should proceed. So just that is my warning about that. All right, let's launch into them. Brian,
All right,
show us our first hypothetical.
Hypothetical number one. Again, we're going to ask you to read it. I'm not going to read these out loud. I'm going to ask you to read them, and then I'm going to launch the poll, and you can answer. So here we go with hypothetical number one. And here comes the poll. I see we have 8 votes so far, and I'm just going to say I think everybody but staff, everybody on the call, we have a mixture of subcommittee members and some counselors that are attending, so I think it's okay for everybody to participate in this. But staff, I guess we're going to keep our opinions to ourselves. We do have, I'm going to go ahead and end this one because we've got a number of votes already, and I will share the results here. Looks like we're unanimous here. This one is 11 out of 11 for people thinking that this should warrant professional discipline. This is actually based on a fact situation that you have in your materials. This is an Iowa case out of 2015, or a case out of Iowa in 2015. Now, I will say Mr. Moothart engaged in a variety of misconduct. There was other stuff than just this. But this scenario kind of brought, I guess, this being one of the fact patterns, one of the individuals that had filed a complaint against him, he actually was asking people to flash him. And that was something where we were looking at the rules and realizing that, you know, it's, I guess there's our rule 1.19 really deals with sexual contact. But if somebody is saying that, you know, hey, I'll reduce your fee by a certain percentage or whatever it is in exchange for flashing me, you know, query whether we have a rule that really covers that, other than some sort of maybe broad argument that it's prejudicial to the administration of justice. So I would say that, you know, this would be a difficult case to prove. I don't know if Carmen has any contrary opinion, but I don't think we really have a rule that specifically covers this one. So nevertheless, Carmen, do you have anything to add on this?
Just that I, under no circumstances, believe that I should use Rule 8.4D just because I can't find anything that actually applies. I am devoted to retaining some real meaning to conduct prejudicial to the administration of justice. So I decline to use it as a catch-all just because I can't find anything else. And I could not find anything else anywhere in our rules that would cover this fact pattern.
All right, so we'll go on to, I don't know if anybody wants, we want this to be a discussion, so I don't know if anybody, Carmen, you know, as far as how we handle this, if we want to open it up for discussion, I guess if there's anything pressing that the
No, I
subcommittee
think
members want
the
to
committee
discuss?
members should be able to discuss each of these
Yeah,
to the extent that they
Brian and
want to.
Carmen,
Yes.
I guess I was just on that one. I mean, I think we all agree that it's unethical to have sex with a client. Is it not unethical to solicit that, even if you don't actually? So are y'all saying that soliciting sex with a client is not unethical? It's just the actual, you have to actually be successful to carry out the act? Because this seems like solicitation. I guess that's how I would read this.
Right. Well, that's a good question, Ted. And I have definitely prosecuted cases successfully on the theory that a lawyer had engaged in an attempt to violate Rule 1.19, which prohibits sex with a client. So whether or not the lawyer successfully had the sexual contact wasn't the issue. It was an attempt. But under circumstances like this, where the lawyer could say, you know, I had no intention of ever laying hand on this client. I just like naked pictures. That is it's sort of ridiculous, but it is actually, it would be, if it were accepted as true, would be a total defense to an allegation of even an attempt to violate Rule 1.19. So I think we're threading through a loophole here, but it is a loophole.
All right.
What was the outcome in Iowa, if you know?
So this person was suspended. I don't recall the length of time that he was suspended, but I do believe it was a pretty substantial suspension. Sorry, I got lost in all the different cases that I've been reading over the past couple of weeks.
Well, the conduct, to be suspended, it seems to me the conduct would have to go well beyond this. And you said it did. There was numerous things.
Yes, there was also an allegation of a couple of allegations of attempting to or successfully having sex with a client while he was representing folks. So that's why he was suspended for a period of at least 30 months. That's what he had. So 2.5 years.
Well, I think what I'm hearing from you, Carmen, is you wouldn't prosecute this case. You wouldn't have a rule to base it upon. If this were the only conduct and this complaint came to the bar as we're reading it here, what rule has been violated?
That is what I'm saying. I mean, I'm sure that we would get the whole Office of Counsel together and try to figure out if there were any rules that anyone could figure out to apply to this situation. But on its face, I think it's pretty problematic. I don't, because I don't use 8.4D just because there isn't anything else, I personally wouldn't feel like I had
Yet 11 lawyers just
that really fit this fact pattern. And Catherine is here. She may have a different opinion than me, which is, you know, more often than not the case, and she's usually right. But I don't know if she wants to weigh in on this one.
Well, 11 lawyers just reflexively decided that this conduct was didn't pass the sniff test.
Mm-hmm.
Yeah.
Okay.
Yeah, so I agree with Carmen that this one is difficult if he doesn't try to arrange a rendezvous or something and then contends that it was just the pictures that he wanted. I mean, I agree that it should be a violation of the rules of professional conduct, but I think Carmen's right that it doesn't actually fit within any existing rule. Which is not to say that another approach to this kind of a thing, you know, if y'all should decide that this needs to be specifically addressed, we might launch a discussion of whether 1.19 should be amended to cover more.
All right. Should we move on to hypothetical number 2?
Let's do it.
All right. Hypothetical number 2. And here's our poll. I think this one's given us a little more to consider here. I'm going to stop the poll shortly. We've got 7 votes in. Give you about 5 more seconds. All right, I'm going to share the results. We've got a mix here, mostly yes, 1 no. So this one is based off of a case out of Colorado. Henry Abrams. It's in your packet where this, I don't know if it was this exact phrase or this is kind of a combination of a number of things the person said about a judge. And you can, it's a pretty long disciplinary opinion, but still there's some good, I guess, just some good thought process from that disciplinary board, at least into understanding what the court looks at in interpreting their version of 8.4G in Colorado. And particularly the person was saying that, you know, he's not trying to be offensive, but he used to use that term differently when he was a kid. And so he was brought up with the term meaning something else and it being derogatory towards a gay person or something like that. And so anyway, the court did not find that to be convincing, and they ended up issuing discipline. I believe it was a very short suspension for this individual. Now, as far as our rules, I think this is one that, again, you could probably try to make the argument that maybe is this an 8.2A, that, you know, are you making a question? Are you calling into saying something that's false or saying something with reckless disregard to the truth or falsity about the integrity or the qualifications of a judge? That's perhaps a stretched sort of argument that it's prejudicial to the administration of justice under 8.4D. You can make that argument, but this is something where you're talking to opposing counsel about how to deal with your case and not, you know, trying to resolve something by consent. Again, to Carmen's point, I agree with it completely. You don't want 8.4D to be just this catch-all of all bad conduct is a violation of 8.4D. Otherwise, 8.4D loses its meaning. So I think this kind of presents another situation where you question whether or not this should warrant professional discipline, and if so, what rule does this really fall under in a clear manner? Barbara.
Question. Yes. I just wonder if people would vote different if the last word was different, because that's what I guess you're focusing on when you say he used this term as a child. I mean, does it matter what the last word is? Is that the difference? That, I mean, if it's...
I think for purposes of this discussion, that is the operative word.
But if it wasn't there, would you say that would everybody say it's not, doesn't warrant professional discipline and it could be handled by another rule? I'd probably
send it to Mel Wright without the last part. I mean, truly, I don't think Rule 8.2 applies here. I don't think this kind of just ad hominem sort of vulgar attack is the type of thing that 8.2 is meant to cover. None of those words goes to the qualifications or integrity of a judge. You know, this is pure just demeaning insult. So yes, I think that is the operative word.
Interesting.
Right. And I don't know, Carmen, do you think this would come under 4.4 as it currently exists?
I would rather, if I were to bring this case to the grievance committee, yes, I would rather try to argue that this was a statement that had no substantial risk other than to embarrass or burden a third party.
Right.
So yes, I would. I think I might be able to make that work.
Yeah. All right, next hypothetical. Let's go with the next one. Carmen, this is yours.
This is mine. This is, yes. So Brian, we'll just take a look at this and then launch the poll and see what the subcommittee.
Sorry, before we go on, can I ask a question about the last one?
Of course.
Do we think the last one would be addressed by one of the two proposed rules?
I think that my 4.4 would address this. I'll leave Carmen to speak about her draft. The 4.4 that I drafted was focused on, I guess you remember 4.4 deals with conduct towards a third person, and I amended this version of 4.4 to say that it's addressed to basically a lawyer's conduct towards a person in the legal process. So it's still connected with a lawyer carrying out their lawyer duties in this justice system, if that's supposed to be the anchor for our action as in regulating the profession. And so I do think that my draft would cover this particular conduct. I do think you can make the argument that the current version of 4.4 covers that conduct too, but it's, to my knowledge, my memory, we have not applied 4.4 towards, I guess, in a lawyer addressing a judge or making a comment about a judge. So that's where I think it would be a little bit more expanded. Carmen, what do you think about your 8.4?
I think it would, yeah, I think my proposal would cover this in that it would prohibit conduct in a professional capacity that the lawyer knows or reasonably should know manifest prejudice on the basis of sexual orientation. So that I think it would. Then we do get into even sort of more complex thought exercises when, a disciplinary question would be, well, would we have to prove that the judge or the target of the insult was actually a member of one of these protected classes? And I don't think, and that isn't even something I've really thought all the way through. It's more, to me, it seems like these rules are designed to not so much to protect the individual as to protect the integrity of the system. So I'm not sure whether that matters, but just the language itself is the problem. So again, there's a lot to think about here.
There is, because I'm almost inclined to think you would treat it the same way, whatever slur fell at the end of that. But if it was idiot,
right.
That if you send it to Mel Wright, you'd send it to Mel Wright. And does everybody understand her reference to sending it to Mel Wright?
Yes, if the Chief Justice's Commission on Professionalism would be the right venue to address this kind of conduct. That's what I was referring to.
So I have a question too. Well, I have a comment first. So I think that it would cover, just because of the last word in there, that it doesn't have, I don't think we have to determine whether or not the person is included in that protected class, because that's one of those words that is just simply derogatory regardless of how it's used. It's not just derogatory towards those folks that are in that protected class. I mean, I like it. In no way is it the same, but I think of the use of the N word. I am an half African-American person, and I know that I'm not the N word, but it's still a derogatory word if used against me. And it would be the same. Hopefully you would feel the same way if it was used against you. Get what I'm saying? So I don't think we would need to do that analysis. So that's that. The other part, thought that I thought of was, what about 8.4G? If we had more information about whether or not they actually did get the case moved to some other judge, or, like cause some damage to the course of the case for the client in some way, because that speaks to what intentionally prejudice or damage his or her client during the course of the professional relationship. So I hadn't really fleshed it all the way out, but I was wondering if that's a way to, because we don't have all the information here, but it seems like if his position on this did cause him to get the case moved from the judge and it caused some delay, or,
Right. No, there could certainly be other ramifications of this that constituted other rule violations. I think for now, what we're trying to do is just distill the conduct in its sort of most abbreviated form to try to figure out what could workably be covered or what should be covered by this kind of rule. So,
Right.
I agree.
So under this one, did the opposing party or opposing counsel report it because of his duty to report it or because of he was offended by it? I mean,
Well, this one, the facts are slightly
We hadn't
altered.
really figured out, like, we didn't really include in there how this information came to light. I mean, I don't necessarily think it matters.
I think what I'm struggling with is that I have heard similar statements made about judges more than once, not necessarily with the F word at the end. I've heard it about some of our female judges with a B word at the end. I've heard, like, I think someone said idiot earlier. I've heard that before. I've overheard it just sitting in court during calendar call. I do not believe any of that is right or appropriate, but I don't know, is there a line we're drawing or are we not drawing a line, and who's responsible for reporting it and proof of it? I mean, I do think most of that's recorded. People aren't paying attention in the courtroom, but I'm concerned about the can of worms here.
Yeah, I think that's good. That's exactly why we wanted to have these conversations. So that's good. We certainly, Brian and I, by putting these hypotheticals in front of you, we're not trying to telegraph that we believe all of these situations should be covered at all.
And we don't purport to think that we can solve all of these today too. It's more of just, these are the different things that could come up in the course of, should we adopt some type of rule? And this is the type of conduct that comes up, and how do we, I guess, just determining the scope of what should a rule cover, and what are the ramifications, like you said, the can of worms. So yeah, it's, I mean, you're spot on, Amy. It's tough at kind of, where does that line get drawn? But hopefully this will just inform us and inform our thought process. All right, Carmen, you ready for hypothetical number 3?
Sure am, Brian.
Here we go.
Okay, here it is. This is my academic setting hypothetical.
And the poll is open. All right, I'll give you about 5 more seconds. All right, I'm gonna end the poll and share the results. This is a lot closer.
Yeah,
5 say
okay.
yes, 4 say no.
All right, well, this is an interesting one. So Dorothy, I see in the chat you said seems like we need to answer those questions separately. Which questions do you mean?
I mean, does this conduct warrant professional discipline, and then separately, is this conduct addressed?
Right. So we don't necessarily expect all of you to have the incredibly nerd-like knowledge of the existing rules. So we were just trying to get, like, your sense of whether it should be covered. And it looks like it's, kind of 50-50 based on the responses that we got. And that's good to know. So this is one of those instances, like I said, that has a lot to do with the scope of the applicability of the rule. How closely are we tying it to client representation, to courthouse behavior, et cetera, or would it extend to lawyers in, say, academic positions? And then the second question really is about, should the rules of professional conduct address sexual harassment, which is basically what this is. We do have a little bit of a twist on this one. Brian, can you just animate that for? Okay.
Well, for one, this is based on a case out of Minnesota.
Right. Okay. So the question is, what if the conduct also included unwanted touching? So that's sort of the modification I threw in there. I don't think we were going to pull this separately, but I am actually kind of curious if that changes the analysis
We can launch it again.
We can, yeah. What if,
There.
what if there was touching? What if there was unwelcome physical contact?
All right, the votes are coming in, and this one is so far. Well, I'll just go ahead and end it because I think that's probably where we're going to be.
Yeah.
Oh, yes.
Okay. So we have a unanimous agreement that if there was also a physical touching component, that should be actionable. And I would say that it is already actionable in that any kind of sexual assault that we could prove, especially in a context like this, with a subordinate, a student, in a professional role, not out at a bar on the weekend, I think we could absolutely pursue on the theory that it was criminal conduct that reflects adversely on the lawyer's fitness. So I don't have too many concerns about the physical contact component of it being addressed by the rules. And as Brian said, this basic fact pattern, this is derived from a fact pattern out of Minnesota in 2013. This adjunct professor made comments about the student's appearance, did make physical contact with her that was unwelcome, and then attempted to persuade her to recant her report of his bad behavior. And he was suspended for 90 days for criminal conduct prejudicial to the administration of justice, presumably for the attempt to get her to falsely recant, and then a violation of their version of Model Rule 8.4G. So in that decision didn't explicitly state whether it would have been a rule violation without the physical conduct or contact, but it's based on the phrasing of their rule, it seems like it probably would have been. It probably didn't require actual assault. Any thoughts about this?
Carmen,
Any more thoughts about this?
Carmen,
Yes.
I have a question. This is
Yes.
Mac.
Hey, Mac.
As an adjunct professor yourself, you know that there is a power relationship between a professor and a student. And part of what offends me most about that hypothetical is that relationship. If that law professor had said that to a fellow professor, I don't know that I'd be as offended. It's rude, but there's no power relationship between those two that makes it abusive in some way. Does that element make a difference to you in assessing whether under your version of 8.4 this is actionable conduct?
So I don't think, I absolutely agree. I think the power imbalance is what concerns me the most about this type of fact scenario. I don't think it would necessarily make a difference in terms of whether it violated at least my version of a proposed rule. I think that based on the definition of sexual harassment that I cobbled together, it would be sexual harassment either way. I think the difference would be in what the appropriate discipline was, because I think someone who abuses a position of power in that way is a much greater threat for future harm than someone who is just sort of lacks a filter with someone who is on equal footing. I mean, I think it would be more in the question of what the appropriate discipline was than in whether the rule was violated. It would be very hard, I think, to build into the rule the question of power imbalance, because, wow, there are a lot of subtleties to that.
Mac, this is Alan Schneider. I agree 100% with you. I think the power imbalance really does make a difference in that situation. I would, although probably many of my clients would not like to hear me say this, I would not have a problem using 8.4D, conduct prejudicial to the administration of justice, to regulate such a power imbalance.
Can we quote you on that in your next case, Alan?
No, sir. No, sir.
Oh, this is on YouTube forever.
Yeah. This is preserved.
All right. I'm only kidding. Only kidding.
All right. Any other thoughts, or we'll move on to hypothetical number 4?
Yes.
All right. Here we go. And the poll is available. I'll give you a couple more seconds here. All right. Here are our results. So we've got 6 that say yes, this should warrant professional discipline, and 3 that say no, it should not. Carmen, you want to talk about this one?
Well, unless anyone else wants to talk about it first. I'm interested in all the ones where we have a difference of opinion.
I voted no, that it wouldn't warrant discipline because it falls under the exception that if you're arguing on behalf of your client, you can argue, there's just an exception that you can go to the places you can't or shouldn't go in other settings.
So, Steve, that's a really good point. And one thing I did notice, I actually didn't notice until today, is that in Brian's proposed modification to, wait a minute, let me make sure I'm looking at the right thing. To Rule 8.4, he says this paragraph does not limit a lawyer's right to advocate on any issue. And Brian, unless I'm missing something, I think
that might need to go in 4.4.
Right. Well, and also there's a difference between this doesn't limit a lawyer's ability to advocate on any issue and the language that was in the model rule that says, hold on. It does not limit a lawyer's legitimate. Okay, hold on. There was the word legitimate was in the model rule. It was legitimate advocacy.
Yes.
And I think that is there. Here it is. Does not preclude legitimate advice or advocacy consistent with these rules. And so what I thought was interesting about this, which is based on an actual case out of 2005, is that everyone agreed, it was essentially stipulated to by the time they got to the disciplinary decision, that the race of the mother's boyfriend or paramour or whatever he was utterly irrelevant to the legal issues in the case. It was, and so it was a frivolous contention, that there was no nexus whatsoever between this lawyer's reference to the race of this person, which was in fact pervasive. I mean, it occurred during the trial too, and what was actually being litigated. So I think it's very important to say that these rules, this type of rule doesn't preclude legitimate advice and advocacy, because if it's just any advocacy, that essentially means you may say whatever you like as long as you can couch it as part of your role as an advocate. So I just think this was an interesting case. This lawyer in Indiana was reprimanded for violating their anti-discrimination rule. And the court said specifically that the lawyer's comments and contentions in the custody petition only serve to fester wounds caused by past discrimination and encourage future intolerance. That was what the court said, which, again, there's so much connection here between the language the courts use to justify imposing discipline under 8.4 G or whatever, and the language in Rule 4.4. Like, there's no substantial purpose other than to do harm, basically. So I think this is an interesting fact pattern, and I don't believe it should be exempted under a well-tailored rule. I think it would be included under prohibited conduct.
Dorothy, did you have your hand up?
I did, but Carmen took my words. I took words right. I mean, I was about, because I read that one and I remember specifically the court's language about they basically just said it just to bring up old wounds and that prejudicial, the prejudice and bias towards the person, and it didn't have anything to do with him being an African American man that does harm to the kids or any of that stuff. So.
Yep. All right. Any other comments about this? We'll move on to hypothetical number 5. All right.
Brian, this is
Sure.
Mac. I have one more comment about this one. I thought the offense in this hypothetical was that the lawyer is arguing that racism should be the basis for a judicial decision. I find that really offensive. It's not as flowery as the language in the opinion, but boiled down, that's what it's arguing, that race should be the basis for a judicial decision. How can that not be a violation of something?
I think it would be a violation of Rule 3.1 under our existing rules. It would be a making a claim or contention that has no basis in fact or law. So I think it would be covered. But as you say, Mac, that for some reason that language doesn't seem to really capture the profundity of the problem with this conduct. People stupid lawyers make frivolous arguments all the time. And that's a Rule 3.1 violation in theory, but this is something entirely different. This is asking, for a conclusion of law based purely on prejudice and bias, which is something that we really do want to be able to address, I think.
Could I point out something else too? Just in response to Matt.
Yes.
I hear what you're saying about that. For you, it boils down to race being a factor for the judicial opinion, for the judge's ruling. But I think that there are times in a case in which race could be spoken about and should be considered in determining certain things. But of course, in a different way. And what I'm thinking about is, like, for instance, if you have a case in which there's an argument about what kind of family the child should be placed with, like maybe in a DSS case, and you're looking at different scenarios, a different family, you have an African-American child and you have an African-American versus a white family or whatever, and that is included as a factor, but not necessarily as the sole basis. So I just wanted to throw that out there just to say that I wouldn't make the blanket statement that it couldn't be used as a part of the decision for a judge in making a determination.
Dorothy, I don't disagree with you, but I think in the hypothetical on the screen, it's racism. And in
absolutely.
In the hypothetical you posed, it is best interest of the child. And
right.
I think there's a dramatic difference between those two.
Oh, I totally agree. I just wanted to make sure we were all together on that.
Fair enough.
All right, we're going to move on to hypothetical number 5 here. And our poll is open. Does this warrant professional discipline? All right. I think we've stopped voting. There's one more that just came in. I'm going to end the polling in just 3 seconds. All right, and here's our results. 3 that say yes, this does warrant professional discipline. 6 say no. This one was, this is not based upon any fact pattern that's in any of the cases that you see. I think this was more so a product of our discussions and trying to understand just kind of what's going on in the world today and what could reasonably happen, that a lawyer would participate in some public protest, particularly in this situation, a lawyer protesting a district attorney's decision about prosecuting a police officer who shot a civilian, and participating with this white supremacist group and so forth. And whether, I guess, is where we get into that question of, are we talking about political speech? Are we talking about, is this a true threat? Is this communicating threats? I view this hypothetical as not necessarily constituting the crime of communicating threats, but as a lawyer trying to chant against, argue against, kind of condemn the district attorney. You as a lawyer have this connection to the justice system, and to participate in that type of demonstration, I think calls into question whether or not that is something that is, I guess, improving the public. Does that help legal services across the state? Is this or is this something that's completely detrimental to the profession and the public's view of the profession? Especially, even considering the political considerations. I don't know that we have a rule that necessarily covers this one. I think you could, again, the best thing you can do is some sort of very attenuated, broad claim that it's prejudicial to the administration of justice. But
I make a motion that we don't talk about Rule 8.4D anymore.
Okay, Carmen.
I mean, I just don't. I mean, that's just. I think it, for many reasons. Like, if that's all we've got, then we don't have a rule that covers it.
Right. Right.
And I personally don't think that we should. I don't think this is within the state bar's jurisdiction. Just my personal opinion.
Motion granted.
All right. So anybody have any thoughts on this?
I do. I think this one's more racist than the last one. If the district attorney is black, by use of the word lynching, the last one was more veiled assertion of racism, thinly veiled, but you're a lawyer, you're in public, you're in a public group. Yeah, I get the political free speech part of it, but I just think it's this example would cry out to me for the type of rule that we're trying to craft here more than the last example.
Yeah, I guess I would just think that that we have to be careful. I guess I just, am just thinking back and totally unrelated stuff about like the dental board case, and I think we have to have a clear nexus to somebody acting in their professional capacity if we're going to try to regulate speech. And if he's in a public protest, then I think, even though what he said is, despicable, I'm not sure that that the bar has a foundation for bringing discipline against him. I think if he's in a courtroom and says the same thing, then that's a totally different situation. But if he's at a public protest, I guess I just feel like that's shaky ground.
I agree, Ted.
All right. Anyone else have any thoughts on this one? All right. Looks like Ted, you won a different vote or an additional vote over. You persuaded Mark. So.
And I voted yes too, because my gut was like, at first, the first part, you're in you're in your personal capacity. But as soon as they started chanting about the DA, since you are a lawyer and could possibly operate and work in your professional capacity with that district attorney in that courtroom, that I feel like there's no way to separate the professional from the personal capacity when it came to that part. I was persuaded though by Ted's statements, but I still, that's what my gut answer was when I answered it.
Oh, I think this one really just highlights especially the general notion that we see in a lot of the law review articles and other commentary against Model Rule 8.4G or just any type of anti-discrimination language, that lawyers should be able to separate kind of what happens in their representative capacity and their professional capacity from their personal views and their political activities. But yet, like Dorothy said, as lawyers, we are kind of always tied to the justice system. That's what the job is, and trying to find this line where our First Amendment rights continue and versus where they are subject to some type of limitation is a difficult one. So nevertheless, all right, we're gonna move on to hypothetical number 6. And here's our poll. All right, that was some pretty quick voting, I have to say. So we've still got some more coming in. I'm going to go ahead and end this one. It looks like we're pretty solid here. One person said yes, this does warrant professional discipline, but 10 other folks said no. This one again is not really based on any type of case that we have, but this is based on one of the scenarios that was posed in one of the law review articles critical of Model Rule 8.4G, specifically talking about a lawyer's ability to give CLEs, any sort of presentation, just voice an opinion that could be interpreted as discriminatory, derogatory, or what have you. So one thing that we kind of did with this one, though, we added a kind of a different twist. And I'm going to relaunch the poll to see if this changes anything for you all. That essentially, if the person went on to say, not just that they thought this was a wrongly decided opinion, but that this just demonstrates that the Supreme Court also is, essentially fall into the gay agenda. All right, I'm going to end the polling here on this one. And we've got pretty much the same thing. That didn't really affect or change the outcome, with one person saying yes and 7 others saying no. So, again, I guess I'll open the floor up here. I don't know if anybody has any thoughts on this one as to whether or not a rule should cover this type of stuff. It seems like we're all saying that it should not affect a lawyer's ability to present a CLE, even if they're arguing against a particular case and the implications, the results or consequences of that particular decision, or remark about, like in this situation, that the high court has fallen prey to the quote gay agenda. Does anybody have any thoughts?
I think that everyone got it right, but I also think about, I see this kind of covering like law professors too, and teaching and giving opinions and all of those things in class. So
yeah, and so this is one I think we're in looking at any potential rule that this committee would craft and recommend. This is something to keep in mind to make sure that any rule doesn't necessarily cover this type of, I guess, what we would call kind of an educational scenario, whether it's a law professor or a lawyer that is speaking at a CLE, essentially to still allow that type of debate and even disagreement amongst peers on controversial topics. All right, we're going to move on to hypothetical number 7.
This is the hypothetical that is very commonly put forward by opponents of anti-discrimination rules. It seems to be fairly ubiquitous, and so we figured we should include it here.
And the votes are coming in fast for this one as well. I think we've reached a fair enough conclusion. I'm just going to go ahead and share these results. This one was pretty unanimous.
Oh, you guys, you all get an A+. this should not and cannot be a rule violation. When I am teaching my law students about being a lawyer, one of the things I tell them about accepting and rejecting cases is that lawyers are not public utilities. The lawyer-client relationship is a fiduciary relationship. It requires a lot of skill and sometimes artistry. And we are not required to take anyone who walks in the door or explain why we don't want to. So this is where the exception to the anti-discrimination rule that says it doesn't limit the ability to accept, decline, or withdraw from representation comes into play. There's absolutely nothing about either the rule that I proposed or the rule that Brian proposed that would require a lawyer to undertake a representation that was contrary to their faith or, offensive to their morals. So I think that one's fairly straightforward. We just wanted to explicitly address it.
Well, in fact, Carmen, I would say that although without condoning such beliefs, that the lawyer under the circumstances who has such beliefs is probably doing the professionally responsible thing and not taking such a case when they have a predisposed notion about such beliefs. So just like with some lawyers agreeing not to take any criminal cases, they might feel the defendant did something so horrendous that they can't zealously represent that individual's interest. And if that's the case, they shouldn't be representing those individuals.
Exactly right. Yeah. No, I mean, clients wouldn't want a lawyer who feels ambivalent or negative about their case, right? I mean, that's not a good advocate. So,
all right. Hypothetical number 8.
Totally agree.
The votes are not as fast on this one. All right, I'm going to end it in about 5 seconds. All right. And here are our results. 9 say that it does warrant professional discipline. 1 person says it does not. Carmen, you want to take this one?
Yeah, I mean, I don't have a whole lot to say about it, except that, I mean, I don't think this is covered by our rules exactly. I mean, I suppose, again, you could go back to the well of Rule 4.4 and say, is this conduct that has no substantial purpose other than to delay or burden a third person? Well, I suppose so, but when you're talking about a discretionary act by a lawyer, an act that a lawyer isn't, you're not required to agree to extensions of time. I think it would be an uphill battle to prove that. The lawyer could say, oh no, you may think that it was just motivated by antipathy towards those of Muslim faith, but in fact it had another purpose, which was to move this case along. And we couldn't really prove that negative. So I don't think this is covered by existing rules. I believe it would be covered certainly by my proposed rule. I'm not probably by Brian's too. I'm trying
I would think
to
so.
think. In Brian's, let's see. But again, Brian's is tied to the no substantial purpose language, the Rule 4.4, and I think that's problematic here because again, there could be another substantial purpose. So if you're saying, well, 50% of this was motivated by religious bias and 50% was motivated by the decision that we want to move this case along more quickly, that makes it hard to prove under Rule 4.4. Either the existing version or the proposed change. So I think that's the question. And going back to one of the prior hypotheticals that we talked about, I think again the harm here is not so much to the, it's not really about an individual so much as what is that client learning about the way lawyers operate and the way the judicial process operates when that kind of language is used, when that kind of sentiment is expressed.
Yeah.
So I don't have an answer to this question. Those are just my thoughts on it.
Carmen, let me ask you a question about your statement that it'd be hard to prove that it was because of religious animus. The lawyer in this hypothetical didn't say he's probably a terrorist and I'm trying to move the case along. The lawyer just said he's a Muslim and he's probably a terrorist. That sounds to me like a pretty square on. It's in a professional capacity, and it is it manifests prejudice on the basis of religion, and probably more stuff. Why would that not be square on?
I mean, I agree with you. I agree with all of the components you just stated. However, I am familiar with the kind of defenses that we get, particularly under Rule 4.4. And generally, I feel like if there is any other legitimate basis that could also motivate the problematic act, it makes it a lot harder to prove a Rule 4.4. That's really my concern, is that if a lawyer has discretion whether or not to grant extensions, the fact that a lawyer exercises that discretion because of animus, I think is, it's not a really strong case. If we're talking about the disciplinary considerations, it's not a very strong case in terms of proof. If they have another explanation, that's my concern.
Carmen, are you alleging that revisionist history takes place in the disciplinary process?
Maybe.
No comment.
Occasionally, could be. I don't know. Well, let's ask Alan. He's really the expert.
Right.
I agree with Mac, though. I think that this is more spot on. And while it may be problematic and a hard case, I think it still is a great case to fight.
Right. Well, and I think, again, I think it would and could be covered under a proposed new rule. I'm talking about what we could do with it under the existing rule.
Oh, absolutely. Because I think it's
that's more of a
clearly
stretch.
right. I think it based just on its face here. I think it's clearly discrimination.
Mm-hmm.
Yeah.
I mean, that's the clear reason why they're not granting the extension is based on discrimination.
Right.
All right. We'll move on to hypothetical number 9. Of course, this is the one that we're dealing with where we start going into that realm of employment discrimination, whether or not employment decisions should warrant professional discipline. All right, looks like voting has slowed down, so I'm going to end the polling and share our results. We're 50-50 on this one. So, yeah, this one again, it's not based on any particular case, but I know this is one of the topics when we talk about scope of these different rules. Should a rule reach into the employment decisions of a lawyer? Does the lawyer have the ability, for example, to set up their law firm and say that our firm has certain values, and upon finding out that a recent hire doesn't comply with what the partner's professed values are, that they can just simply fire the person? Now, currently, of course, our rules don't cover this. I think a potential rule that dealt with some type of or prohibition on unlawful discrimination could deal with this. But again, we have that question of where does that proof need to occur? Does there need to be a separate tribunal that reaches the conclusion that this was unlawful discrimination before the state bar could pursue any sort of professional discipline on this scenario? Love to hear everyone's thoughts, though.
I think the rule is drafted, and as Carmen pointed out earlier, that the bar doesn't want any parts of this case until that other tribunal has made a determination is the right one.
Anyone else?
So in this case, the EEOC or a court would have to make a determination that there's been discrimination, and then the bar, it may be appropriate for the bar to impose discipline.
Right. And I think that's the consideration for the Office of Counsel is what sort of burden do we place on the Office of Counsel and this process, not just to investigate, but ultimately to fight through, like as Carmen, I think, described earlier, the notion of having to prove an employment discrimination case based upon the various federal laws that exist out there, for which we are not experts. Is that something we expect of the state bar? The Office of Counsel does look at other existing statutory laws to establish, say, a violation of 8.4b. To say that somebody has committed a crime, then we have to sometimes prove the elements of those crimes have actually occurred, even when the DA has not taken the steps to charge that person and actually complete prosecution. But this may be a little different because it's just employment law can get quite messy. So I think that's where I'm curious to hear the feedback of the subcommittee if you feel like this should be something that we really want to pursue, or do we have that requirement, essentially the hurdle, that if you're going to pursue professional discipline based upon unlawful employment discrimination, that you have to get some sort of resolution from a separate tribunal first?
Hey, Brian, I just want to point to the time here.
Oh my goodness. Okay, good point. Let's get moving. If there's, I don't think there's anything else here, so we'll go on to hypothetical number 10. This is where we get a little more cringy.
Brian, can you wait just a second before you put those things on the vote? Because
oh yeah,
or at
you
least
can
for
also
me,
you can move the poll window around on your screen. Although if you're using like a
iPad, it's not easy.
Yeah. Okay.
Sorry about that.
Yeah. I'll hold off.
Can you pop it back up, Brian?
Yes. All right, so I saw some quick votes came in. I think this is, I'm gonna go ahead and end the poll and share those results. This is a pretty solid no, this should not be covered. I think this is one of those questions when we look at rules of what constitutes an unwelcome sexual advance. You have the question of who's I guess interpreting the approach by the male lawyer as an unwelcome sexual advance, whether that should result in professional discipline, whether we're talking about the setting, it's a local bar social. Is that acting in a professional capacity if you're at something like a bar association function or something, things of that nature. So I think that's, it looks like we're kind of clearly saying no, that should not be a professional or something addressed by professional discipline. But then we wanted to add some additional facts here to see when does this start to change. So I'm launching the poll again to say, is it professional misconduct if the male lawyer is a partner at the female lawyer's firm where she is an associate? Does that change our answer as far as whether that should be dealt with via professional discipline?
Probably just changes the fact that she reports him. That's my guess.
All right, we got a couple of votes that just came in here, and it looks like this one, I'm gonna go ahead and end that and share that. We've got a swing. We've got 6 people say that yes, this is professional discipline, and 3 that still say no, it does not. And then we added yet another one because we wanted to make clear just what are we talking about? What if we're talking about a lawyer who's approaching a paralegal as opposed to another lawyer? So again, I'm launching the poll to see if that changes anyone's opinion. Is this professional misconduct for a lawyer to approach a paralegal in this manner?
I'm assuming we mean a paralegal employed at the lawyer's firm.
Yes, that's, yeah, I should have been more specific there. I mean, I think, whether and it looks like this one, I'm just going to go ahead and end this and share this results. This was 7-1. Yes, this is professional discipline. So nevertheless, I think that's just, again, we're trying to find the line of not just the setting, but the conduct as well. And it looks like the very first scenario, standing alone, we felt did not warrant professional discipline. But that when you add in, I think, Mac, what you had described previously as kind of the power dynamic, that suddenly changes our analysis of this situation. Unless anybody has anything pressing to say, I'm going to move on. We only have a couple more to go through, but I would like to get everyone's thoughts on these. So we're going to go on to number 11 here.
And this one is thematically related. And what I think is really valuable about getting the subcommittee's feedback on these is that, as I'm thinking about it and hearing from all of you, what I'm recognizing is that if we are to include a sexual harassment component in a proposed rule, the definition of sexual harassment is going to be a challenge. It's going to be really challenging because there are a lot of things that, grown-ups say to each other, and, we need to be able to handle most of those things without the intervention of a regulatory agency. So I think there is something that could be a really difficult piece of this, is trying to cover situations where victimization seems to be part of it, which obviously, based on these poll results, this was not designed to demonstrate that. I mean, this probably happens at almost every holiday party of lawyers across the country. I mean, it's not, but I think this is just a good illustration of how much work we would need to put in if we want to address situations that actually reflect adversely on a lawyer's professional character, and not just the fact that someone might have had a moment of bad judgment or said something crude. Because if that's the standard, I'm in big trouble. Not that this is about me, but just as an aside.
Carmen, not to intrude on your personal relationships, but just a question. If lawyer number 2 were a prosecutor, lawyer number 1 is a prosecutor, and lawyer number 2 is a defense lawyer that frequently appears in the courtroom that prosecutor runs, would that change your opinion?
No. No, I feel like grown-ups need to be able to just point and laugh at other grown-ups who are propositioning them. I mean, but again, you asked my personal opinion, and my personal opinion is that it wouldn't change my personal analysis.
I see what you're getting at, Mac.
I know. Mac is like just subtly Socratic methoding us, which is unnerving.
Professor McCarley.
Sorry.
All right, let's look at number 12.
This one was also somewhat inspired by Gray Wilson sent us some potential hypotheticals, and this one really just was sort of inspired by one of his that has to do with language, with unwitting perhaps use of terms that maybe or are definitely offensive.
All right, we've got some results here. I'm going to go ahead and stop the poll and share those results.
Okay.
One person says yes, 10 people say no.
So my take on this is the kind of thing that I would absolutely try to address. Like if this were reported to me now for any reason, I would say, okay, someone just needs to talk to that lawyer. Someone just needs to have a sit down and say, here's the thing. I understand you used to use these words. We don't use those words anymore. They are hurtful. They carry a lot of weight and insult with them, and we don't use them anymore. And overwhelmingly, that's going to solve the problem. So I just don't, these are rules of reason, and we need to be reasonable. And I don't think we don't need to be the politically correct language police. This is really more about I think malevolent intent or reckless disregard. And I think, sometimes people don't keep up with language.
Right. And once again, not to say that it's generational, but also with some older folks, I think this is born more out of naivete and ignorance as opposed to necessarily, a malicious intent or some bad nefarious intent. But I think educating them and letting them know what's, proper terminology today is the way to go. But I think this should result in discipline?
No, exactly. I mean,
male right
what's that, Colin?
Like a male right kind of conversation.
Exactly. Or even just with a colleague, with someone in the bar, someone who knows the lawyer. I mean, I will tell you, whenever bar counselors have referred to lady lawyers around me, I just gently tell them that the correct term is lawyerette, and then it's problem solved. Easy.
I have to play devil's advocate on this one because I have had to have those kind of conversations, Carmen, that you're talking about with lots of people because of the use of, especially, all three of these terms. And I would go out on a limb and say that if we revise our rules, that this should be covered under that know or should know, reasonably should know that this language that is offensive. Because while we kind of talking about it lightheartedly, like for me, the use of the words Oriental and colored folk is highly offensive. Oriental for the Asian side of me, that's referring to me as an object. So, and I've had to have this conversation with lots of people. So that's why I say, depending on who you are, that's a personal, seriously personal for me to hear those. As soon as I read those, I was like, you know what I mean? So I don't think that it would necessarily just fall into we could just have the light. And I'm not making light of the way you're saying it, Carmen, please understand that. But I don't think it should just fall to we could just have a light conversation with somebody and say, we are in new times. It's clear, it should be blatantly clear to everyone that these are just inappropriate.
I agree with that. I agree with that, but I wanted to hire Alan as my lawyer because where that came from was I actually was corrected by my daughter working on her PhD several years ago about the use of the term Oriental versus Asian. And so, there's a learning curve there when phrases change. And I think, there should be an appropriate time period, especially for the elderly people, as Alan said, for that adjustment to take place. But I agree with what Dorothy said. I don't think those phrases are acceptable.
And Dorothy, just so you know, I find all of each and every one of those terms offensive. And my comments were just simply to say that I know people, whether it's an uncle, whether it's of loved ones of mine who have used terms not realizing that those are terms that should not and should be used under any circumstances, but because they did not know from the standpoint of those terms being offensive. But education and telling people, look, those terms are not acceptable under any scenario is important to get the message out there.
Agreed.
Yeah, and Dorothy, to your point, I think, once that conversation has been had, then the lawyer knows, then we are squarely within we're not even talking about reasonably should know, it's then the lawyer knows. And so any continued use of that kind of language would be a violation under the proposal. So I agree with you. It's not a conversation that anyone should need to have twice.
I will say that
Carmen,
the examples you used are things that everybody should know. But I'll just say personally that until recent, I didn't know that, I had not heard the term like Latinx. And some people would say you shouldn't you know, you shouldn't maybe refer to someone as Mexican or this or that. You should say Latin X. And so there is a learning component. You know, I'm continuing to learn of things that maybe aren't as obvious as this, that I might say inadvertently that I shouldn't, that we need to be more careful about.
All right, let me ask a hypothetical. We change the hypothetical slightly. If it's the associates in my firm, knowing that I'm 68 and I say something they don't particularly agree with, and they look at me and say, okay, boomer. Clearly age related. They clearly knew what they were saying. Is that offensive? Does that break the rule?
Oh gosh, this is my slide, isn't it?
Yep.
Yeah, well, that does seem to that does seem to manifest prejudice on the basis of age. I'll give you that.
I think I think it all depends on, and even with these terms, I mean, like I said, I have strong personal views about these, but if I have to look at this objectively, as we are wanting to do right now, I think it is all in, you have to look at the context in which it's used. So if it's like what you all are saying, the way you're looking at this is that this person just doesn't know and they've used that, and then someone talks to them and they're like, oh, okay, now I'm educated. But if they're referring to, like what Ms. Christie said, if you're calling all those Mexican people, you get what I'm saying, when you're referring to Spanish speaking persons all the time, and then you're using it in a derogatory way, as opposed to you're saying you're calling someone Mexican because you just don't know whether you're assuming that they are Mexican, which is not an assumption you should make, but you get what I'm saying? I think it's all, you have to look at the context in which it's used. I mean, we go on with this because, I mean, I think it's offensive for someone, like I said, to refer to assume someone's race, because like for Asian people, for instance, it is highly offensive to call a Korean person Japanese. Koreans are extremely offended by that based on the historical aspects of those relationships. But most people a lot of people may not know that. You know what I mean? So it all is in, you gotta look at the context.
Yeah, I agree.
So I go back to the whole thing that underlies like our PMBR study and things that we've said. We believe the vast majority of lawyers want to do what's right if they know it. And so it underscores kind of the importance of, you know, the CLE that we're going to require, and the, you know, the study and the training and the informing people, instead of just using discipline as a stick. But anyway.
This is Colin. I think those things really, like Dorothy says, require a lot of context. I mean, personally, I represent the Tuscarora Nation on some matters. And when I sit down with members of the nation, we talk about Indian, and they talk about Indian things and Indian people, and, you know, and they don't seem to think that's offensive. That's their language, and it's the way we communicate, and it's not intended to be, they don't refer to themselves as Native American. And so, I mean, I think you have to apply a little bit of context, and it's hard to draw black letter rules for, you know, whether a word in a particular context is offensive or inappropriate.
I agree, Colin. And I think taking it back to Mac's hypothetical, it is whether something is actually a manifestation of prejudice is very context specific. No word hanging out there in the ether is going to in itself demonstrate prejudice. You know, I mean, we're using all sorts of offensive language in this slideshow. Just because the words are there doesn't mean that anyone here is manifesting prejudice, you know, so you have to put it where, you know, in the setting. And I think, you know, for your associates, Mac, I seriously doubt that what they're doing is manifesting prejudice. I think they're just manifesting their good-natured, friendly relationship with you by, you know, saying, okay.
That can be their defense.
So we're certainly not going to, yes. When Alan represents
that
them.
Can be when Alan represents them, that will be their defense. That they didn't mean it as hurtful and demeaning. They were just being kind and friendly.
Also include in your defense, Alan, that Mac's a snowflake.
I absolutely will.
I mean, we could take that example to the other side too, because I mean, I think we all hear so much more now about the references to millennials and people being dismissive towards them, and you know their mindset and how they are and all of that good stuff. So, both ends.
Good.
All right. Well,
we got one more to run by you.
All right. This is our last hypothetical.
Oh, boy.
So this one is inspired by a case out of Maryland. Some of you may have heard about this one. This case actually came out in June of this year. So curious what you all think. Does this warrant professional discipline? See, some of the voting has slowed down. I'll give you 3 more seconds. All right, so we have a split. 5 say yes, this warrants professional discipline. 4 say no. So this one, like I said, this comes out of a case out of Maryland. This dealt with 2 lawyers in the Veteran Affairs Office up in Maryland, and it really actually dealt with 5 separate lawyers. These 5 lawyers, only 2 of which were licensed in Maryland, so that's why they only addressed 2 lawyers. But these 5 lawyers were engaged in what they called the Forum of Hate. It was an email exchange amongst the 5 of them, where they would just send these completely xenophobic, racist, misogynistic comments, just horrible stuff back and forth to each other, intending for it only to be seen by them. But it was all supposed to be just, their way to vent and engage in some inappropriate humor amongst friends. Those emails were eventually discovered by the office because these 2 lawyers from Maryland were using their government accounts to engage in this form of hate. And I don't know exactly how the emails were discovered, but they were discovered and reported to the bar. The Maryland courts, their disciplinary process, and ultimately their court determined that this violated their version of Rule 8.4G and issued these folks an indefinite suspension. I believe, I cannot recall the time that they have. They can apply for reinstatement, I believe, after something like 2 years, if I'm remembering that correctly. But nevertheless, they were suspended from the practice of law for this conduct. Now we had I wanted to add the additional twist in here that to kind of add that factor in. I'm curious, do you all agree with the Maryland court that this changes if the lawyers they're employed by the state, employed by a government office, and they're using their government issued resources, cell phone, email account, something like that? Does that change your decision or your analysis of whether this warrants professional discipline?
Well, and during business hours, right? And on work time.
Yes, and on work time.
I think it makes the conduct more egregious because, I mean, it's egregious either way, but because you could assume the risk that if you're sending this out on a state email system, that it's going to be seen by other, by people other than who you intended to, whether it was just 3 or 4 your close friends.
And all right, so I'm going to end the polling here and share these results. So we had a 6-3 vote here. 6 folks say that it does warrant professional discipline, 3 do not. One of the things that the opinion goes into talks about just this notion of, well, this stuff, these comments, they kind of recognize that these were inappropriate comments that they would not ordinarily say out in public, but they were only intended for select eyes. And the court addressed that argument by saying that, essentially to create some sort of standard that misconduct only occurs if the lawyer knows that it will be publicized would be just a ridiculous standard. that essentially the misconduct that occurs, even if it's kind of occurring, quote unquote, privately, is still misconduct. And that is what needs to be evaluated. So that in that way, they just rejected this notion that it was supposed to just be amongst friends and not ever reach the judge who they were referring to by this term. This is the specific term that they were using, and amongst a number of other things that they said. So anyway, with that said, open it up for your thoughts, discussion. Now we're getting close to our 2-hour limit here.
Under our proposed rule, how would you consider that in a professional capacity?
I would say yes. I think if a lawyer is sending their, well, I guess maybe this is where you get into the, I guess when they're acting as a lawyer for the government, without question, I feel like that would be a professional capacity in using your state issued phone on state time to email other lawyers, other people that you work with, and essentially make derogatory comments about judges who you appear before. I think that would be something that the new rule would cover. Of course, whether or not we feel like this type of thing, like this should not be covered, I guess is subject to debate.
I guess I was talking about your first original hypothetical, text message, 3 friends. I mean, what if they weren't lawyers? Is it, what about that makes it your professional capacity?
So I think if it's just 3 friends, kind of say 3 friends that are not lawyers, to me, I have a hard time saying that's professional capacity. That one, I'd have a very hard time saying that's professional capacity. If you're just talking, not necessarily as a lawyer, when you're talking with other lawyers in your district about somebody that you all appear before, I think that would be conduct that, even though you guys are talking friendly, or you're friends and you're just kind of goofing around, so to speak, you're still potentially engendering bias against somebody who will be interacting with that person in the legal process. I guess that would be my initial gut reaction.
I'm going to disagree. I'm going to disagree here.
I'm going to highly disagree too. I mean, there are many things that I might talk about with my twin brother and my 2 or 3 best friends from college. I'm not even talking about things that are, but just that I wouldn't talk to other lawyers about, or I think we can go down.
Well, even if it is other lawyers, from a disciplinary perspective, I don't want to try the case where I am trying to prove that a weekend conversation amongst a few lawyers who are friends is subject to discipline. To me, that's just to me, this case was appropriate because of its context, because the only thing they could have been doing between 9 and 5 using their state issued devices was being a government lawyer, and that, to me, that was the hook.
Yeah.
So,
well, and to clarify my explanation, what I was trying to, I guess, articulate is what could the argument be for a professional capacity thing? I don't know that the Maryland court, frankly, said that this is only decided because they were acting on their state time. I don't know if they made that specific distinction. Again, I could just not be remembering the facts as specifically as that. But that being said, I guess, and that's something just, again, to generate that conversation. Could you make the argument that it's professional capacity if you're talking to other lawyers at a bar function and you're making these comments amongst friends, whether it's a text message or you're sitting at the table at the Wake County Bar Luncheon, versus, is that something that we want a rule to cover? And I guess, again, it's food for thought in terms of crafting the application, because I know that was one of the things that in the definition of professional capacity, and correct me if I was misreading your rule, Carmen, but I think you had social functions or comments that are in like a local bar social function could include acting in a professional capacity. So that's I guess we just need to think about how this could be carried out in crafting this definition.
And I want to get back to thinking about what our role is, big picture. Who are we protecting? I mean, isn't it the public? Isn't that what our job is? And isn't that why we want to self-regulate? So, no one else tells us how to do that. I get really uncomfortable with having valuable state bar resources used on prosecuting people who make comments among friends just because your friends happen to be lawyers.
I think we need to be very careful about the distinction about state issued phones and computers. I mean, those are going to be employment related issues that are, I can tell you from having been in the state capitol where every misuse of state property for 27 years is reported, there are hundreds of, solicitations to go to the liquor store and do other less glamorous things that you really don't want to get into.
Yeah, Amy, I tend to agree with you that we really and it may be that the committee may end up deciding, we don't even want to include social functions. We don't, that just because you happen to be at a social function with, that's not the way I wrote the definition. When I said bar related or professional related social activities, what I had in mind was, like formal bar events, but it may be that that's just going too far, and we don't need that. That's not really the point.
I don't think that we should completely abandon it though, that notion, because there are oftentimes, a lot of times, that we can all admit that when we're at a social function, we end up talking about professional matters with other people at the function that are lawyers, which then transforms us from just being there in our personal capacity to the professional capacity. I know that's tweetering, and I kind of see this, it's not exactly the same, but somewhat well, never mind. That's what I have.
So I've been listening a lot and not really saying anything, but on this one, I feel like it's important to point out that from the point of view of trying to prosecute a case, this would be almost impossible. Or even if, let's say, there was a fourth person involved who was deeply offended, I think that they could easily make the argument, well, I didn't know that was offensive to this person. If it's hard to draw a line and say it's okay to say these things among people who agree with you. But if you say the same thing to someone who doesn't agree with you, that goes over the line. I think you really need to think about the context does matter, but also the context can create a big problem for prosecution.
Yeah, I agree with you, Catherine. I think that's one of the challenges of this kind of rule too, is making clear that the harm that we are trying to prevent does not, whether or not the harm exists, whether or not the rule violation exists, cannot hinge solely on the individual reaction of one person. It's not, the question is not, was someone offended? It's, what is the overall impact of this type of conduct on public confidence in the profession and in the system? We got to keep coming back to that. And that's, I think, when we get into these discussions about social conversations and friendships, first of all, I feel uncomfortable in my role policing such things, but also I think we're getting further and further away from those core concerns.
And I can see this where, let's say you're sitting at one of those 8 people tables at a bar function, and 3 people who share these noxious views are saying this among themselves, and they're not directing it to anybody else, but somebody else hears it. There are just an awful lot of nuances to this that would have to be thought through. If you were going to try to include this kind of thing, you've got to really think about all of these different permutations and how you would like to see that work, and whether it's feasible to try to make that work.
I agree with everything. And I actually agree with you, what you stated about policing this social thing. I just wanted to make it clear for you and Carmen that I wasn't saying that we should police this kind of thing. I was just merely pointing out the fact that we wouldn't just want to completely abandon having some way to police some of the things that could happen at a social event that could transform into having conversations about professional matters, and that could, have some bearing on those professional relationships and those things.
Yeah. And I'm not saying I know the answer to this question. I'm just pointing out that comes to mind to me as if I'm sitting there getting ready to try a case, anticipating. And Alan, I'm sure, is thinking the very same thing from the other table in the room.
I wouldn't have a problem defending the 3 or 4 friends who are speaking amongst themselves, whether I agree with what they're saying, and even if I thought it was horribly wrong, if it's not intended to stay within the confines of 3 friends, whether they're from college, they have nothing to do as lawyers, I just don't see us using our resources to use the disciplinary apparatus to regulate that.
I have to say, I'm totally satisfied with that position. Alan, I'm curious, do you think the Maryland case was correctly decided?
Which one was that again?
The form of hate. These guys that are emailing amongst themselves, albeit 2 using state issued things. I guess just the email amongst themselves. Was that objectionable, or does that warrant professional discipline? Not to put you on the spot.
No, I mean, it's not. I mean, it's a close one because the wording is so outrageous. So I'm struggling with that because the content, what they said, is just so horrific that you want to find a way to regulate it, but at the same time, you have a conversation between 3 friends that's not intended to go outside the confines of those 3 friends. And so I probably err on the side of regulating it because I'm just so appalled by the actual language that was used, but I'd struggle. I mean, it's a close call.
They're also clearly a threat to the public if they believe that you get to have private conversations that are going to be kept secret via email.
I could not agree more. We've all learned a lot about social media, emails, texts, and and how non-private they are. But so I'd say because of the just the really offensive language and what I wouldn't have a problem with the Maryland decision. My clients might want me to argue otherwise. I probably could make an argument otherwise. But me personally, I felt it.
All right. So Steve, once again.
I have a new hypothetical.
Oh,
I have a new hypothetical. Would you discipline Jeffrey Toobin for his conduct on a Zoom conference?
No, he's been disciplined already. He's been disciplined already.
He claims it was an accident, right?
I believe him.
You would.
I mean, come on, Carmen. You think, I mean, do you really think that he put his video on and audio on? No.
No,
You think he brought this upon, think he wanted his kids and his wife to see him all over the news? I mean, no, I think it was
maybe inadvertent, not accidental.
There's nothing that this regulatory body can do to discipline him that will punish him more than he's been punished as a result of his actions.
True, but Alan, you just announced the knew or should have known test related to technology. Well, he knew or should have known.
That's a good point. Wow.
Since we're running out of time, I'm going to have to Google the Toobin thing because I'm a little in the dark here. But where do we go next meeting, guys?
Just type in his name and it's all over Google.
Yeah, I promise you, not typing anything else for Toobin.
But Steve, I can save you the trouble. It's exactly what you fear it is.
Oh man.
Poor Jeff. Steve, I'll say, no, we're talking about what's coming up next. I think we need to make a decision on whether or not we want to address the preamble. This kind of concludes our educational portion of this subcommittee. So I think, there's some food for thought. There's 2 draft proposals that were just kind of our first attempts, and maybe I'm certain that they can be improved. I don't know if we want to go to that next step or if we want to talk about the preamble. There's a lot of different things. So I know we're at the end of our meeting here. Steve, I'll leave it to you if you want to talk offline about that, or if we want to take the temperature of the subcommittee. Are we feeling ready to address the preamble, or do you want to go in a different direction?
Well, I first off, thank you very much for today. You both proved yourselves capable law school professors, again, with some challenging hypotheticals. And it really got my wheels spinning, and many of these were close calls, and they're the ones that we need to be thinking about as we draft the rule. I also want to remind everyone of Carmen's colorful guide. You know, this last thing we were talking about is, you see directed to a person well down going toward the red. That's the kind of language that's going to help us craft a rule that's going to pass constitutional muster, I think. I think for next time, that's what we want to do is talk about the preamble. And just to remind everyone, there was a publication of a preamble that would address, give us just aspirational language about non-discriminatory conduct and language. And what we're talking about is a rule that would cause such conduct to be subject to discipline. And, you know, as David Allen said from the start, we can do one thing, we can do the other thing, we can do both things. And I think we need to probably, well, that's something we may want to address next time up front. And then the second thing is, I'm comfortable, if the rest of the committee is, with starting to like getting deeper into the proposals from Brian and Carmen. So I'm interested in any thoughts on where we should go from here, but that's what I'm thinking.
I agree.
I agree. I think we
do
have
as
to
well.
get to the language.
Yep. And I think Dorothy's points about maybe taking bits and pieces of both rules, I think that both of them did an excellent job taking bits and pieces of both of them and merging them together and coming up with a rule that addresses the conduct that we all can agree on should be regulated.
And I wonder if today's polls have made Brian and Carmen think of ways the language may need to be tweaked to meet what we all think we want, or the majority thinks they want, that we aren't really thinking in terms of how the rule's written.
Yes, Amy, I was absolutely just thinking that what I think I would like to go back to the drawing board a little bit and then, you know, recirculate based on some of the conversation today.
Great. Thank you, everyone.
Unless we have anything further, I guess we're adjourned. And Brian, I'll talk to you offline about tuning up the agenda.
That sounds great. Thank you, everybody.
Thanks, everybody.
Thank you,
guys.
Brian. Thank you, Carmen.